1989. Nintendo sues Blockbuster for photocopying game manuals. It's no secret that major software publishers have always despised rental services because they think rentals rip into their profits. In the late 80s, video rental stores would rent out computer software, which was fully legal because the rental stores bought their copies fair and square and were within their rights to lend them out. But of course, the United States Congress was lobbied to put a stop to software rentals by a number of companies, including the Software Publishers Association, WordPerfect Corporation, Microsoft, shocker, and of course, Nintendo. Soon, a new rental protection bill passed through the Senate Judiciary Committee, which prohibited rental stores from lending computer software. However, unfortunately for Nintendo, NES game cartridges were not included in these protections, so stores like Blockbuster were allowed to continue renting out NES games. Thanks to this exclusion, Nintendo decided to work around it by going after Blockbuster directly through their game manual photocopying practice. Now, to provide context here, Blockbuster did have a policy where they would charge customers extra if they lost a manual, and thus they resorted to simply photocopying them as a cost-efficient means of creating replacements. Both companies would reach a settlement out of court for an undisclosed amount, and despite their efforts, Nintendo would continue to be left out of the Computer Software Rentals Amendment Act, meaning it was still legal for stores to rent out NES games. This was a big win for consumers, but many game publishers were still resentful, and eventually they would turn their spite towards used game sales.